Hello everyone, and thank you for joining us this morning. I'm Zainab Ghulam, Policy and Public Affairs Advisor at the BIA, and today I'm your chair for this session on what the National Security and Investment Regime could mean for your company. The National Security and Investment Act was recently passed by Parliament, and in Whitehall the systems are currently being set up ahead of the regime coming into force on the 4th of January 2022. This legislation gives the UK government more powers to look at transactions and investments into UK companies from both foreign and domestic investors, covering mergers and acquisitions as well. This is something the BIA has been working with our members, parliamentarians, and the Department for Business, Energy and Industrial Strategy on to better understand how this might impact the life sciences sector and to try and mitigate any negative impacts on investments into our sector. Over the last year, the BIA has been working closely with BEIS and the Office for Life Sciences on the sector definition of synthetic biology that the NSI regime sets out, sharing feedback on this from BIA members and highlighting the impact it might have on our sector. This webinar follows on from our previous webinars and workshops on the NSI regime, with a particular focus on the sector definition of synthetic biology, which has now been published in secondary legislation and will be before the House of Commons and the House of Lords shortly. Today, I'm joined by an excellent panel who have significant experience working with and on the new regime already. We'll be looking at what the regime entails, how it might apply to the biotech sector, and hopefully we'll be able to give you some ideas about what your company might need to do to adapt in response. Joining our panel, we have Jackie Ward, Director of National Security and International at the Department for Business, Energy and Industrial Strategy. Jackie is heading up the Investment Security Unit at BEIS, which will process the notifications as part of this new regime. We're also joined by Kat Kingsbury, Special Counsel at Covington and Burling, who works in the firm's Foreign Direct Investment Regulation team and has been supporting clients through the new system. And finally, we have Mick Cooper, Life Sciences Analyst at the Office for Life Sciences. Mick has been working on developing the definition of synthetic biology and addressing some of the concerns of BIA members. As we go through this webinar, please do use the Q&A function to submit any questions or comments you might have. Our speakers will be able to come to these in the second half of this session. If I could just ask that any questions or comments that are posed are not transaction or deal specific and are more general. To kick us off, I'd like to ask Jackie to come up and give us an overview of the government's national security priorities and why we have the NSI Act. Thanks, Jackie.
Fantastic, thanks very much, Zainab, and good morning, everybody. I hope you can hear me. So I wanted just to start by saying a huge thanks to BIA and its members for all of the engagement to date on the NSI Act. And indeed, well before it was an act, as it was a passage through Parliament as a bill, and indeed under development as various form of green and white papers. It's been quite a journey, and we're hugely grateful to BIA, amongst many other organisations, for the ongoing shaping of the work, particularly on the definitions of sectors that are subject to mandatory notification requirements, such as synthetic biology, which we'll be talking more about today. So in these opening remarks, I just wanted to give you an overview of the NSI Act, explain a bit more about the workings of the Investment Security Unit, which, as Zainab said, I lead, including some of the processes that will happen under the Act. And then I'll close those introductory remarks by saying a few words about our approach to engaging business, particularly should you wish to follow up after this call. So the important thing to say by way of opening is that the new measures are really designed to make the investment screening process simpler and quicker for investors and businesses than the arrangements that you may know about under the current Enterprise Act. So although the new NSI Act achieved royal assent on the 29th of April this year, so it's on the statute books, it will only fully commence from the 4th of January 2022, so in a few months' time. So what does the Act do? It strengthens the government's current powers to scrutinise and intervene in investments and other acquisitions so that we can protect our national security. And I think it's important to say that it is a change to our approach in terms of the national security tools available to us, rather than a fundamental change in the UK's approach to our national security. So it's not developed in response to a particular understanding of a new threat. Really, it is a long overdue and long planned upgrade to the legislation underpinning investment screening, and brings us much more closely in line with many of our allies. So as I've said, it gives businesses and investors a much clearer and more predictable screening process with more clearly defined statutory timelines and processes for decisions, all with the aim that people can continue to confidently invest and do business in the UK. The UK is absolutely still open for business, and this new Act does not change that. We hope, in fact, it helps and simplifies and streamlines. So in terms of how the government becomes aware of a transaction taking place, there are two possible ways that this might happen. Through a notification made by the parties to the transaction, either voluntarily or in the mandatory sectors. I'll say a bit more about that in just a second, or through our own work in scanning the market and just becoming aware of potential national security risks. So I've touched on the mandatory sectors, which we'll be talking about in a lot more detail today. There are 17 what we call particularly sensitive sectors of the economy, such as artificial intelligence, synthetic biology, types of communications, and particular activity in those sectors, transactions in companies that particularly perform activities in those sectors must be notified under the legislation to the government, and that will be through the Investment Security Unit. I think Catherine's going to talk in a bit more detail about those, so I won't dwell here on these opening remarks, but of course we can take more questions. I'm going to focus a little bit more on the nature of the national security risk, and therefore the call-in power that the Secretary of State has, which is what he will use if he reasonably suspects that a transaction does give rise to a national security risk. As I've said, but it warrants saying repeatedly, the vast majority of transactions absolutely will not pose a risk to national security and will either therefore not be notified to government if they're outside of the sensitive sectors, or if they are notified, they will be screened out very quickly, very early in the process. But if I focus on the assessment process, the period of time after the Secretary of State has called in a transaction because he thinks that there may be a national security risk, he will turn to the Investment Security Unit to look for advice on the national security risks that transaction presents. There's a couple of ways in which we might be engaging with businesses during that period. If the national security risk is very severe or very day one and present, then it is possible for the government to impose what's called an interim order, so to halt certain elements of the transaction from proceeding whilst that assessment is undertaken. And we may, throughout that period, be in touch with the parties to the transaction to require further information so that we can understand what's going on and hopefully, if there is a need to intervene, design mitigations that are as light touch, protecting national security, but ultimately allowing the transaction to proceed. So as you might have inferred from that, a call-in has three possible outcomes. The transaction could be cleared to proceed. Just because it's been called in, it doesn't necessarily mean that on further examination there is definitely a risk to national security, so it could still be cleared to proceed with no further action taken. It's possible that the Secretary of State may wish to impose remedies to constrain or protect certain bits of the business or the transaction in the name of national security. Or in the most extreme, and I should say in only the most extreme circumstances, the transaction can be blocked under the legislation if it poses a national security risk. And once that decision has been made, it can't be reopened by government unless it's actually been made on the basis of any false or misleading information. So that decision is in fact final and binding. So how will the Secretary of State use these powers? So we'll shortly be publishing something called the Section 3 statement. It pertains to Section 3 of the NSI Act, which will set out how he expects to use his call-in power. And hopefully this will help investors and businesses such as yourselves to understand more about whether your transaction is of particular interest from a national security perspective, and to decide whether or not to notify, particularly if it's outside of the sensitive sectors. It sets out some of those risk factors that the Secretary of State will be considering, and therefore how also the call-in power will be used in some of the other elements of the legislation, such as assets. So we've already consulted on a couple of versions of this statement, most recently over the summer. Very many thanks to anyone who responded to that consultation, and we'll be shortly laying it before Parliament for the final round of scrutiny before commencement. So just a few words on the investment security unit itself. As I've said, it's based in the business department. That's absolutely no accident. We want to ensure throughout this process the smoothest and frictionless transaction for business as possible. But it's important to say that we don't expect to retain all of the expertise needed to screen investments within the ISU. We'll be working incredibly closely with our partners across governments, with sector lead departments and with the security services as well. And effectively the ISU therefore plays a coordinating function, coordinating that advice to the Secretary of State. So for example, as mentioned, we've got the Office for Life Sciences joining this call, who are an incredibly important partner for us, particularly in transactions involving synthetic biology. So what we hope that this will do is enable us to have a single coordinating function, but also draw on the real benefit of expertise right across government, whether that's sectoral, diplomatic, or legal, as well as, of course, the national security assessments that we'll be formulating. And all of that comes together in advice to the Business Secretary. So finally, just a few words about our plans to continue to engage businesses and investors, which we've been doing a lot of throughout the development of the legislation and on our preparations for commencement. Our communications campaign has focused on delivering teach-ins such as these and guidance for a cross-section of businesses and organisations to build understanding, and for those who are most directly affected to know how to comply. So we'll continue to do that in the run-up to commencement. We'll be running many more sessions such as these. We will be continuing to explain the different elements of the guidance that we published in July, which is a really comprehensive kind of overview of the Act itself that can walk people through step by step, as well as some more specific elements such as how it might interact with other regulatory regimes. And later this autumn, we'll be publishing a further tranche of guidance, which will include an explainer of the mandatory sectors, the sensitive sectors, for which the statutory instrument was recently laid in Parliament. So hopefully that will be a bit of a sort of more layman's terms explanation of the kinds of activities within those sectors that are included. And finally, within that set, I've mentioned the Section 3 statement, so that's also coming as part of the set this autumn. So the really important thing to say is the investment security unit exists. We're here setting up the regime, but we're also talking to businesses about their queries for any future transaction, or indeed any live transactions that they are having contemplation or in progress at present. So please do feel that you can reach out to us. We have a dedicated mailbox, investment.screening@bays.gov.uk. We can of course make that available following this session, and we're really keen to engage, whether it's through wider teach-ins such as this or on specific transactions. So please do reach out to us if you have any questions, and I'm sure many of those will come up today. So I'll stop there and say thank you very much.
Thank you, Jackie. That was really comprehensive. And you mentioned at the end all the guidance that the government has now published. The BIA has been part of an expert panel that's been consulted on this guidance, and I would really encourage people who are looking to understand the regime a bit better to read this guidance. That's all available online. It does give a really comprehensive and kind of layman's an overview of the regime in layman's terms, and also just how it connects with other bits of government compliance that are often necessary. So I definitely would encourage people to check that out. Thank you, Jackie. Next, I'd like to ask Kat from Covington to join us to talk about how the regime is expected to work in practice, some of the timescales associated with each part of the process, and what kind of transactions need to be notified under which system. Thank you, Kat.
Thank you. I think in a moment there should be a couple of slides. Thank you very much. And we're just going to use these as a bit of a visual aid to lay out some more details of the specifics of how mandatory and voluntary notification works and the overall structure of the Act, without hopefully being too legalistic. It's already been mentioned that the Act will come into force on the 4th of January 2022, so that's the first working day of next year. But at the same time, the national security and investment regime has some immediate relevance because there were anti-avoidance provisions included in the legislation, which means that once the Act comes into force, the Secretary of State will have a 6-month period in which to potentially call in any transaction that has occurred since the 12th of November 2020, provided that the Secretary of State is aware, of course, that the transactions occurred. This means that transactions ongoing today could potentially be reviewed, but also that parties that are in the planning stages of an investment or that will occur in the early part of next year also need to be thinking seriously about the NSI regime. So we can split the regime then into 2 parts, as has already been mentioned. There's a mandatory filing element to the regime, but we can also talk about where voluntary notification would be available. The regime requires mandatory notification for entity-level transactions, and those transactions where an interest is acquired that tips particular thresholds, being the acquisition of a 25%, 50% or 75% interest in shares or voting rights of an entity. Mandatory notification could also apply if an investor requires the right to block or pass any form of resolution of the target. And of course, mandatory notification is only applicable if the relevant entity, the target, is active in one of those 17 sectors that's been mentioned. There's a full list of those sectors on the next slide, and of course, as you'll all be aware, we'll be specifically talking about synthetic biology today. The voluntary element of the regime then addresses that wider and residual power left to government to review any transaction in the wider economy, and that Jackie has described in terms of where the government might want to exercise that call-in power. In general terms, it's notable that that wider power exists regardless of the size of the target company. It can apply regardless of the value of the transaction, and it's also possible for any transaction to be reviewed in any sector under that power. So whilst the core sector definitions remain relevant under the voluntary regime, they are not a limit on the types of transaction that could be reviewed. Voluntary notification then may have its place for borderline cases for mandatory filing, but also for other transactions that have a profile that includes potential national security risk factors, and where the parties just want to achieve certainty that that reserve call-in power will not be used in the future. And the relevance of that is that the call-in power might otherwise exist for up to 5 years post-closing, although it's expected to be possible to shorten that review period, that potential call-in period, to 6 months, by ensuring that the government is aware of the transaction. Importantly, asset transactions are only covered by the voluntary regime, and while assets such as land and tangible property are within the definition of assets, where the voluntary regime applies, so also is intellectual property. And this makes the UK's national security and investment regime a little bit unique compared to some of its comparable regimes overseas, because the transfer or license of intellectual property is potentially subject to review under the national security and investment regime. On the next slide then, well, you'll see that list of the core sectors that's been mentioned, and it's in where the target has activities in these sectors that the mandatory notification requirements of the regime apply. Many of these areas are self-evident in terms of their subject matter, and it's important to note that the regime is intended to be one for which the parties can make a self-assessment of whether they are required to make a mandatory notification. At the same time, however, what we do notice is that these definitions are also very detailed and quite specific. And that's good because it shows that there's been a serious attempt to really limit the mandatory filing requirements to the areas of greatest interest for national security, and to do that at the outset. But it also means that it's necessary to have quite detailed information about the specific activities of a target entity in order to determine whether a filing is required. And I'll come on and say a little bit more about that and what it means in practice in a moment. By way of an overview of procedure then, and Jackie's already touched on some of this, but we've laid out here some of the steps in terms of how filing is expected to work. So very specifically, mandatory notification, or indeed voluntary notification, is made by an acquirer, not by the target entity, and it's expected to be submitted through an online system. There will then be a period of initial review of the notification, and the option will be there for the ISU to request more information before an application is accepted. But once fully made and accepted into the system, there will then be this two-phase review period. So the first part of that review period lasts for 30 working days, and that will involve that initial assessment to determine whether the call-in power would then be exercised and whether the transaction would be called in for more scrutiny. As Jackie has mentioned, it's expected that the vast majority of transactions will indeed be cleared at this stage. And if it's cleared and provided that all information was correct, parties may then proceed with their transaction. So from a transactional and investment planning perspective, what needs to be prepared for here is really the time to make an assessment of whether you're subject to mandatory notification, to prepare that filing, and there is a standardised form for the filing, and then to provide the time for this 30 working day period to expire before you'll be able to proceed with your transaction. However, for those transactions where call-in is requested, then a phase 2 assessment will commence. And this will also last for another 30 working days, but could be extended at the option of the Secretary of State for a further 45 working days. It could also be extended again where necessary and with the agreement of the parties. Transactions, as Jackie has said, can also be cleared at the end of phase 2, but where a national security threat is identified, provided that there hadn't been interim orders already, then it's really at the end of this phase 2 process that we would expect to see those final orders being made. And the Act indicates that there is broad scope to make orders of different types as applicable to the type of transaction, and of course following other principles of public law, including to act only where necessary and to impose measures that are proportionate to the identified risk. The last slide here today just provides an overview of potential outcomes and exposures under the Act, but I'm just going to focus really on one point on this slide, and that is that the failure to obtain clearance where mandatory filing is required will lead to a voidness of a transaction. And in this, although the Act provides for that voidness to be cured, it's really the seriousness of that sanction and non-compliance, which is why the national security and investment regime matters so much, because it may lead to circumstances in which, from a legal perspective, a transaction has actually not occurred in the way that the parties intended. I can leave the slides behind there then, but I was also asked to comment briefly on our experiences of the national security and investment regime so far. And the first point I just want to mention is that, you know, the UK is not alone by any means in revising and updating its powers in this area. The EU passed a foreign direct investment regulation in 2019, and following that we've seen many EU countries update or adopt foreign investment regimes as well, and that's happened particularly so in the last 12 months and at pace. Alongside that, we've really seen health come in the frame more as a national security risk. Some regimes have introduced measures that are directly linked to the COVID-19 pandemic. And the broader point of relevance that we've taken from that is really that the concept of national security inevitably has a political and cultural and economic relevance, and it can be a flexible measure that can change over time and will be something that the parties need to bear in mind when considering their transaction and over time, and particularly where an investment may change and there will be different opportunities to review a transaction at different stages in the life cycle of an investment. The other thing that we're seeing, and my second point and where I'll finish in a moment, is just that we're seeing really transaction parties and advisors beginning to develop their processes to deal with national security and investment review. And as mentioned, the national security review does tend to require a level of detail and information that hasn't typically been available in deal planning processes so far. So we're seeing due diligence adapt for that. In any event, there may be circumstances where it's very difficult for parties to share, or they would just be unwilling to share the types of information that are necessary to complete a national security investment assessment and determine whether filing requirements apply. So there are a couple of pathways through that. One is to sign an agreement with some kind of general condition that indicates the parties' agreement that they will indeed comply with necessary requirements, but to leave it until a later date post-signing to actually identify what those specific filings are, so that the parties can then share, more detailed information when there's a greater level of commitment between them. Another way is to really place the burden of identifying a mandatory filing requirement on the sell side and target side of the transaction, and doing that through due diligence and through warranties. And placing that assessment risk with the target makes a lot of sense in terms of overcoming that need to disclose specific information. It can also help in shaping some of the arguments around whether a voluntary filing might have benefit in certain instances. And also, when we think about the venture capital space and early stage transactions with multiple parties that might have different individual filing requirements based upon the level of control that they are separately acquiring over the target, it can be helpful for the target company to take the lead in those circumstances. By no means essential, but by placing some responsibility with the target, it's helpful for the company to really sit at the centre of that process sometimes and assist the investors in aligning their approach. It can also be a way of pooling some of the cost and time associated with managing the transaction. But this is all very early stages. Each transaction will be specific to its facts, and we look forward to seeing how things evolve over time. Thank you.
Thank you so much, Kat. That was really comprehensive, and I think particularly walking us through the process step by step and all the different elements of that process is really helpful. Just a reminder to please submit any questions or comments or thoughts you might have in the questions box, and we'll be coming to those after we hear from Mick. So Mick, we are really pleased to have you join us, and looking forward to have you talking us through the sector definition of synthetic biology that Jackie mentioned has now been laid in secondary legislation. Thanks, Mick.
Thank you. So yes, I'm Mick Cooper. I have a PhD in developmental biology and joined the Office for Life Sciences a bit over a year ago, having worked as a sell-side analyst for the previous dozen years. I'm here to represent the OLS side. We've been working very closely with the national security community on the definition, but I am not a national security policy expert myself. At the end, I will attempt to answer your questions as fully as possible, but I'm afraid there are certain things that I won't be able to elaborate on because of the nature of national security. I will start by setting out the process we went through in developing the definition, and then walk through the definition itself. Many of you will have seen the first version of the definition that was consulted on in late 2020, then called engineering biology. As Jackie set out, the definition identifies those transactions which are subject to the mandatory notification regime. The earlier draft would have impacted nearly every transaction in the life sciences sector and was significantly broader than the final definition we have now. The initial approach taken was due to the diverse nature of the specific national security risks that potentially exist within the life sciences sector. However, we felt this approach seemed to be disproportionate to the risks we understood there to be, and would have had a disproportionate impact on the sector, which of course we wanted to avoid. So we worked closely with colleagues from several departments across government, and after many robust but constructive discussions, the definition was significantly narrowed by agreeing to some major exclusions. I'd like to take this opportunity to thank the BIA and their members for their detailed input and efforts to represent the sector throughout the process, which is very useful. I'm sure there are frustrations that the definition was not narrowed further, but it's important to note that the intent of the Act is to protect the national security of the UK, and this was the primary consideration when we developed the definition, and in some areas, the national security community raised particular concerns. Unfortunately, there are potential dual-use security risks associated with synthetic biology, and we recognise that some activities within scope may appear innocuous, but these have been carefully discussed with national security experts. As I mentioned before, there are reasons, which I cannot go into detail on, why parts of the definition needed to be structured in the way they have. Ultimately, the final definition is consistent with the intent of the Act to protect the national security of the country while limiting the Act's impact on the sector in areas where there is limited risk. Unfortunately, this means that much of the sector should not be impacted by the Act, allowing the application of synthetic biology for the benefit of the UK. To turn to the definition itself, the legislation had to include a definition of synthetic biology to determine the scope of interest. For the purposes of the regulations, it's defined as a process of applying engineering principles of biology to design, redesign, or make biological components or systems that do not exist in the natural world. Bar the clearly defined exemptions, which I will come on to later, for entities that carry out scientific research into synthetic biology, development of synthetic biology, production of goods using synthetic biology, and formulation of synthetic biology to enable the degradation of materials will be subject to mandatory notification. From this point, we were able to agree a series of significant exemptions to the mandatory notification regime. These have been determined through close consultation to take a proportionate approach to identified risks and try to achieve the best balance we could. In summary, there are a set of exemptions set out in sections 5A to F, and section 6 sets out another category of exemptions. The exemptions set out in 5A to F are as follows: general services and servicing not related to core synthetic biology, bioremediation, diagnostics, industrial biotechnology research, the production of substances ordinarily consumed as food or used as feed, gene therapy where a missing or defective gene is replaced, and cell therapy with ex vivo cell modification. Following this, Section 6 sets out a further set of exempt activities and says that the ownership, including of intellectual property or development of both human or veterinary medicines and immunomodulatory approaches are also exempt, unless they have a synthetic biology technology that could be employed or modified to produce and/or deliver toxic chemicals, and any of the things set out in Schedule 5 of the Anti-Terrorism, Crime and Security Act 2001. Although we recognise there will remain some points that companies wish to raise, the proposed wording was agreed as a workable compromise, allowing the application of synthetic biology for the benefit of the UK, but reducing the risks posed by misapplication of the technology. The Life Sciences Vision was published in July. Companies working with synthetic biology are critical to the government's ambitious plans to build and maintain the UK's position as a global life sciences leader. In delivering both the Life Sciences Vision and the UK's bioeconomy strategy, we are keen to work closely with industry, academia, and medical research organisations in order to support the continued growth of the sector. And I think that with that, I think it's over to questions, Zaina.
Thank you so much, Mick, and it's great to see some questions starting to come in. If I could ask all of our panelists to turn back on their cameras so that we can see you all, and that you can all take turns in answering some of the questions that we have. I would really like to start with you, Jackie. You mentioned that the we have a few months before the regime comes into force. It will start to apply from the 4th of January. What is your team doing in the run up to this to support businesses to prepare?
Thanks, Zainab. Well, I mean, I've touched on some of that in my introductory remarks. I mean, fundamentally, we're extremely keen to talk to businesses right across the economy, because as Catherine says, we're understandably focusing quite heavily on those businesses that are in the sensitive sectors because of the mandatory notification requirements. But we do want to make sure that businesses right across the economy are aware of the changes and are able to think through if and how they apply to them. So we're doing lots of sessions such as these. We're working with industry organisations such as the BIA. We're working with law firms, investors, banks, and so on, those who might be advising their clients. And we're also particularly working to target small and medium-sized businesses to make sure that they're also aware of the changes happening to them. So we've done sessions such as these. We've been pushing out guidance materials and communications toolkits for people's use, for information cascade, and to be able to draw on various products. And as I said, we've also been speaking directly to businesses if they want to talk to us about a particular transaction that they have in contemplation or progress, so that they can understand the likelihood of the legislation applying to them, whether or not it's happening this side of the commencement, given, as Catherine mentioned, the ability to call in back to the introduction of the bill, or whether it's for a future transaction. We're very happy to talk to businesses either way.
Great, thank you. I think if we come to you next, Mick, we have a question on how the UK's inclusion of synthetic biology compares to regimes in other countries. Is this something your team might have looked at, or and maybe Kat, you might be able to come in on this as well?
It was considered, and yes, we did look at it. I'm afraid, top of my head, I think it's similar, but I'm not an expert on that. There are other people that are much more informed about it than I was. That's
right. Kat, did you have in your kind of experience of other regimes in other countries, do you think the UK's inclusion of synthetic biology compares?
Yeah, I'd agree with what Mick says there. I mean, I think it is basically comparable. If anything, it's a little bit narrower. I think at the beginning of the COVID-19 pandemic, we saw, as I say, a lot more attention on healthcare. As a couple of examples that come to mind, the French have had an FDI, foreign investment review regime, for a while. And at the start of the COVID-19 pandemic, they added into that as a sensitive sector biologics. And I think that is the sense that I have, particularly in the EU and a couple of other jurisdictions, is that the focus tends to be on more broadly biotechnology and biologics, and particularly if targets in those jurisdictions are doing research and development into things like biologics, then it would potentially be covered by the mandatory sectors in those regimes. But the UK, as I say, from our perspective, has potentially taken a slightly narrower approach, and indeed probably helpful to the sector, in that it's focused more specifically on synthetic biology, and with a detailed definition of what that means.
Thank you. I think that's a really important point about how it relates to COVID-19. We've just had a flurry of questions in, so I did have a question related to that, but I'm just trying to find again. Sorry, give me a second. Oh yes, Jackie, I think this might be good for you, but again, if anyone else would like to chime in. Is there any intention to use this regime to stop acquisitions of companies developing vaccines that might be useful for future pandemics?
Thanks, Zainab. I mean, the important thing to say is that this legislation is solely focused on national security. So when we're drawing what's within and without scope, it's all with the direct intent of trying to identify a national security risk, not a competition risk, not a public health risk, but a national security risk. So there are other pieces of legislation, the Enterprise Act, which of course has until now covered national security. Effectively, the national security components of that are spinning out. So if there is a connection or a risk back to the UK's national security, then that's effectively what we're looking for. If we're looking more broadly at kind of competition or supply chains, then that's not generally something that this legislation would be used for, which isn't to say that there might not be other regulatory procedures or other pieces of interest. So I think it's just really important to sort of keep that focus on the national security applications of the technology being acquired or the company being acquired.
Thank you. You mentioned other regulatory. Oh, sorry, Mick, did you want to come in on that?
I was just going to make one comment on it, that during the formation of the definition, the one thing which was important with the pandemic in mind, and bearing in mind the support that the BIA and its members helped us in responding to the pandemic, was maintaining the health resilience of the country. So that was a consideration when we were developing the definition.
Great, thank you. Jackie, in your response, you mentioned other regulatory procedures, and the question has come in about obtaining information from the Export Control Joint Unit. The question specifically is whether export control filings would be a fruitful source of information, or whether it's considered that the export control legislation is too distinct from the policy goals of the NSI Act.
Sure, it's a good question, and I hope you can still hear me. So I'm getting an alert to say my network connection isn't very strong, so I hope you're still picking me up. So we'll absolutely be working very closely with the Export Controls Joint Unit. There are, of course, potential parallels, particularly in how an asset transaction could be considered under the NSI regime, but ultimately they are separate pieces of legislation with potentially separate aims, certainly separate definitions. Obviously, there's the very specific control list for export controls, whereas we're using our mandatory notification sectors, and there is some alignment, but they are slightly different for different purposes. We'll be working really closely with the Export Control Unit, and we'll share information as appropriate when it's right to do so. We'll obviously be we will be gathering and being given great deals of sensitive commercial data for a specific purpose that is set out in the Act, and we'll be using it in those ways. So we'll be really making sure that we're only sharing information where it's right to do so to protect national security. But of course, if that's necessary, then we can do that.
Thank you. Sorry, again, another question for you, Jackie. In your earlier remarks, you mentioned that companies can approach the ISU to get informal advice. We've had a couple of questions on this. I guess the first question would be, can companies approach the ISU for advice, or should it only be the investors? And then a follow-up, how quickly can we expect a response if an informal inquiry is then made to BEIS?
Absolutely. So anyone can contact us. So whether it's somebody who's considering making an acquisition or somebody who's raising capital and looking for investment, so we're very happy to have a conversation with whichever party to a transaction is necessary. In terms of the timescales, so the statutory timescales are not yet in force. So to some extent, it may depend on the complexity of the question. So there are companies who we may have been talking to for some time because they have an ongoing transaction, and so it's it's one conversation, but they're keeping coming to us, and we're keeping that dialogue open as their work progresses. But generally speaking, we're seeking to operate those statutory timescales, so to get back to people within that 30-day period. So although it's not sort of statutorily binding at this point, we're generally finding that we're able to get back to people in that kind of time, if not quicker. Obviously, there's many circumstances where the transaction might mean that we're having more of an ongoing dialogue, and hopefully that would be mutually beneficial.
That's great. And how many cases do you expect to be referred every year? I know at the start of the legislative process, BIA's made an approximation of how many cases. Are you able to elaborate on that number and whether that's been reviewed in light of the definitions having been published?
Sure. So we set out in our impact assessment the numbers that we're broadly anticipating for each stage. So we set out sort of companies who might be approaching us for what's referred to in that as early familiarisation discussions, and then notifications, call-ins, remedies, and so on. We haven't updated those numbers because we do accept that there is some uncertainty in those numbers. We're ultimately using broad modelling. So the changes that we've made in narrowing, should logically reduce the numbers, but it wasn't sufficient to really update the modelling to you'd be sort of working with sort of slightly false precision. So basically, you'd be able to see from those numbers that of an overall block of mergers and acquisitions in the economy, we'd really be expecting a very small number to be a very small proportion, to be notified to us, an even smaller proportion to be called in for further scrutiny, and a very small subsection of those to have those remedies or potential block that I spoke about. So effectively sort of whittling down to only those transactions that pose the greatest national security risks.
That's great. Mick, I think if we could come to you. We've had a question in on the synthetic biology definition particularly. The question is, what level of modification should be considered to know whether a product could be used to deliver a toxic chemical, which I believe is one of the provisions within the definition?
This is, in some way, this is going to be a legal thing, I feel, and I'll answer best I can. But if it's easily convertible, now essentially you can say anything can be converted from being something safe to something toxic. But if it's a close derivative of a toxic or toxic compound, then it ought to be notified.
Thank you. And Kat, if we could come to you on this, is that and just kind of about how you might approach that from a legal perspective.
Yeah, so I think this picks up from a part of the synthetic biology definition where effectively you've already determined that something is synthetic biology, but you're trying to establish whether an exemption could apply, and the exemption is that the particular substance or could not be easily modified into something that's toxic. And it's been really helpful to hear from Mick today about where the sort of policy objectives behind that. But I think this is, and it's good to know that what's being looked for here is something that's kind of readily convertible. But as we look at this from kind of an advisor perspective, I expect that when we're trying to apply that definition, and at least in the early stages, that it will come down to the substance of the arguments, not the substance itself, but with that in the picture as well. And that this is the kind of point that we would either want to reach out to the ISU on to discuss, but we can see that or indeed present arguments, in some kind of short paper, to kind of outline whether or not we think that the particular product is meant to be captured here, because we can see that that is an area where some detailed discussion is needed, and from a legislative perspective, it's probably very difficult to set out exactly where that applies and doesn't, and it will come down to potentially notifying, but then using the notification to make the case, I think, for whether or not something is easily convertible, whether or not it should be considered to be a threat. And it makes sense to us that the regime needs to work in that way.
Great, thank you. Kat, if we could just stay with you for the next question. You mentioned earlier, you gave a bit of an overview of the voluntary notification system, and the question we have is that the person asking this says, it sounds as if a biotech company would benefit from voluntarily notifying any investment or licensing agreement involving vaccines or biological therapeutics in order to achieve certainty. So I guess the question is, would that be your reading, and would you be able to go back and explain a bit more about the timescales associated with the voluntary regime and how much the timeframes within which an acquisition could be called in under the voluntary regime?
Yeah, so I think it's a good question. I think for lots of transactions in this sector, that will be part of the thought process. Is it better to just notify and gain that certainty? But I think as the regime develops, we can hopefully become a bit more nuanced about that and where we think the risk really bites. But it is a new step for particularly, I suppose, early stage companies to have to think about and make that kind of risk assessment. But once you're considering a voluntary notification, I guess there's a couple of ways to approach that. And one is to do some kind of informal outreach to the ISU to just kind of test the arguments. But if you wanted to then proceed to a voluntary notification, the same timelines really apply as do under the mandatory notification regime. So once you've made that notification, it's the same 30 working day initial assessment period, and then a decision on call-in, and then potentially, if something went into a phase 2 assessment, then another 30 working day period with the possibility of extension. But once you've decided to notify, it's the same regime. I think the other point to mention is that we expect, and I think some of the notification details are still being developed, but one of the measures that we expect to be available is this means of almost just ensuring that the ISU is on notice of your transaction. So possibly sending them a copy of a transaction announcement as a means of ensuring that the unit is aware of the transaction. And then we understand that the call-in period would be shortened from 5 years to 6 months. So in that sense, there is some potential certainty that you can achieve through that route. Certainly on a forward-looking basis, if you're trying to ensure that there's effectively a clean history to the company for a future sale, for example, or future investment rounds, there would be some certainty delivered there that if you hadn't heard anything within 6 months, that effectively you'd address the risk. And Jackie, please correct me if I've overemphasized there what's supposed to be achieved by kind of let's say a notification rather than a voluntary filing.
Yeah, absolutely. I mean, as you said in your remarks, Kat, I would always recommend having a conversation with us, particularly in these early stages of the application of the legislation. So, as you say, the Secretary of State through the legislation has reached back powers for 5 years, or 6 months from when he could have reasonably become aware of the transaction. So, a sort of one-line email that says we might have a transaction may or may not constitute reasonable awareness. So please do just come and have a conversation with us. It's not, I'm sure no one on this call thinks it's a sort of a question of getting around the legislation. It's a question of understanding the risk and doing that in a managed way. So, we're having a discussion here about the limits, if you like, of the mandatory filing regime. In the end, fundamentally, what we're interested in is there a national security risk? Because if there isn't, we're not concerned from an ISU perspective. So, we're very focused at the moment on the mandatory definitions. That makes perfect sense. But once we've sort of formally been notified, if you like, and are considering a transaction, we're considering a range of factors, not just the target and the sector that the target's in, but the acquirer and the level of control that's being acquired. So I know that's sort of slightly further down the process, but I think it's always good to sort of remind ourselves why we're putting these processes in place. It's to identify if there's a national security risk, and if there isn't, then we want the investment to keep flowing into the UK, and we want to sort of keep out of the way as far as possible.
Thank you. I think we have time for 2 more questions, and one of them links back to what you just said, Jackie, about getting in touch with the ISU informally. one of the questions is, what level of disclosure about the company is appropriate during that informal outreach? And I think maybe Kat, you can also come in on that.
Yeah, absolutely. I mean, you know, inevitably, if there's a little bit of a chicken and egg here, in order to be able to give you confidence that that we think we would not be interested in something, the more we know about the transaction, the better. We're of course very used to handling commercially sensitive information, so if that's a consideration, you know, please do just let us know and keep talking to us about that. If it's a question of understanding the stage and the consideration of the transaction, that might take us to the kind of scenario that I spoke about previously, where we may have been talking to somebody for some months because their transaction has progressed, or the expectation of the acquirer has changed in that time. So it can be an ongoing dialogue rather than a touch-in. Once we've got the notification form up and running, you know, you'll see that in effect, in order to notify us formally, whether that's a mandatory notification or a voluntary notification, there are a certain number of things that we need to know in order to be able to accept that as a valid notification. So once we've got the legislation up and running, that will be a sort of, if you can complete this information, then you have enough to be able to let us know. Obviously at the moment it's a little bit more of a dialogue, but you know, effectively the more you can tell us, the greater sort of assurance we'll be able to, the greater confidence with which we'll be able to say that it's something that sounds to be of potential interest or not.
Thank you. Kat, did you want to come in on that as well?
Yeah, and just briefly, I mean, as Jackie said, there is a standardised form, and that would need to be completed. We also understand that there will be options to upload potentially to the system other background information that the parties want to apply, and I think that would just be a matter of judgment in each case. Depending on the time available, you know, the urgency of the transaction, depending on the arguments that the parties wanted to present up front, to really explain what they thought was or wasn't the national security risk. I think it's useful that the system has that function, so that parties can do have some ability to lay the ground in the way that they think best for the transaction, whilst at the same time, you know, meeting the particular requirements of the form and the information that the government will need at a minimum to understand what's happening in the transaction.
I think that's really useful practical advice to conclude the webinar on. Thank you so much to our excellent panel, Mick, Kat and Jackie, for talking us through the detail of the regime, their experience of it, and for answering all of your questions. Thank you to everyone in the audience for joining us and for submitting questions. Apologies if we hadn't got round to answering your questions. It's been a really fruitful discussion, I think, and I hope everyone has found it useful and are feeling better prepared for the commencement of the regime on the 4th of January. The BIA does have a resource repository on our website with lots more information on the NSI regime, which I'd encourage everyone to go and have a look at. It's in the membership section of our website under developing your company. And as Jackie mentioned earlier, the government has already published a tranche of guidance on the regime, which is really useful and really comprehensive. That's all available online, and I would really encourage everyone to review that as well. Finally, the BIA has a few events coming up this week and later on in the coming months. So if you are interested in attending any of these, please do visit our website to register again. Thank you again to all of our panelists and for everyone for joining us for this session. Goodbye.